And the Supreme Court has unanimously made a decision declaring as unconstitutional the law that allowed government to impose restrictions during the COVID-19 pandemic. Parliament in 2020 passed the Imposition of Restrictions Act, which allowed the president to restrict public gatherings, shut down schools, and also to impose measures to guide religious gatherings, amongst others. Law professor and human rights advocate Kojo Appiagyei, along with some 8 others, dragged government to the Supreme Court, contending that the said law was unconstitutional. The court agreed with this view. Legal Affairs correspondent Joseph Akaple has more.
So the case filed by law professor Kojo Appiagyei raised concerns about the process that had been used by the government to impose restrictions. He had made a point that they should have acted under Article 21 to impose those restrictions. That part of Ghana's constitution allows restrictions to be imposed in the interest of public health and safety and crisis where necessary. But Professor Etua took the view that using Article 21 amounted to suspending fundamental human rights in a manner that he considered unlawful. He took the view that it was important that government should have sought to control the COVID-19 pandemic by using emergency powers which were allowed under Article 31 of the Constitution. This provides an elaborate procedure for such restrictions to be imposed, including the presidency consulting the Council of State, as well as going through various steps to outline those measures. The court agreed with his views and declared as unconstitutional the Imposition of Restrictions Act and proceeded to strike out that law as unconstitutional, null and void and of no effect. Professor Appiagyei says he's delighted by this decision.
The decision means that the law which was passed in the first place was illegal. It was unconstitutional. It shouldn't have been passed because there were sufficient provisions in the Constitution to direct how the emergency should have been organized. We also made reference to the Public Health Act, which also gives an idea of how emergency should be organized in case there's a public health emergency in the country. And so that is what the court decided for us.
But we know that the president over the weekend announced that he had lifted the restrictions. I guess it means that they will not be able to, in the event they want to utilize the law that allowed them to issue those EI, they will not be able to do so anymore.
No, they will not be able to do so. But the case had come up earlier, before the president made the announcement last week. And that announcement alone also wasn't enough because the restrictions came by a law. And so they are not, the president just making a statement does not change the law. And so we are glad that the Supreme Court itself has pronounced that the law is illegal, is unconstitutional, it shouldn't have been enacted in the first place.
We know that government has since announced that the COVID restrictions are lifted, but the law Imposition of Restriction Act is no longer a lawful tool because of the decision of the court. So it will mean that in the event they want to issue any executive instrument on the basis of that particular law, they would have to go to Parliament and have the law passed, or perhaps use the Article 31 emergency procedure that the Supreme Court spoke about on Wednesday. For joining news from the Supreme Court on this particular matter, my name is Joseph Akaple.
Let's stay at the courts because the Supreme Court has, in a unanimous decision, described as unconstitutional the directive from the presidency asking the former Auditor General Daniel Yao Domelevo to proceed on leave. It will be recalled that the presidency in July 2020 asked Daniel Yao Domelevo, as then the Auditor General, to proceed on leave. When Mr. Domelevo pointed out this as unlawful, his leave was further extended from 123 days to 163 or 67. And now 9 civil society groups decided to sue the Attorney General over these directives. And after more than 2 years, the court agreed with them. Legal Affairs correspondent Joseph Akaple has further details on that as well.
The Auditor General was probing key government contracts when he was asked to proceed on leave. This included a controversial Kroll and Associates contract involving the senior minister.
Yoko should go to PPA and find out why did they ratify it. I don't see why they are on the back of my staff. For the past 2 or 3 weeks, they've invited my deputies and several officers. I think it's one of the intimidating principles or approaches being used. But then I want to assure them that they can come and jail me. We will not stop doing what we are doing. I've said it time and again that I don't fear any attack on my office. And It is. I'm not alone anyway. Let me share with you for you to know that it is usually the fate of Auditors General. I have a cartoon from the Auditor General in Kenya where he's sitting on his seat and people are cutting so to remove him, and they say they can't figure out how to do this. I have several other examples where I don't want to mention the name of the this, but the president has almost put a ban on the Auditor General because the Auditor General is exposing him too much.
In another African country.
Another African country. So it is all over. The independence of the Auditor General.
Mr. Domelevo insisted the directive was unlawful. The presidency further extended the leave from 123 days to 167. This effectively meant the Auditor General was never coming back, since by the time the days elapsed, he would have been due for retirement. 9 civil society organizations, including the CDD Ghana, took the matter to the Supreme Court. They contended that the directives were unlawful since the president does not have the power to exercise such disciplinary control over independent bodies. The Apex Court agreed with this view. In a unanimous decision, it described as unconstitutional the directive from the presidency that asked Mr. Domelevo to proceed on leave. The court also said it was unconstitutional for the president to appoint an acting Auditor General while there was a substantive Auditor General. It, however, opted not to issue any other orders since the Auditor General had already proceeded on leave and retired.
This matter shortly, but let's start off because there are two issues at stake: the COVID-19 pandemic and what we're hearing about the then Auditor General. But I want to bring in Professor P.J. Etia, who's a human rights advocate, joining us. First of all, on the executive instruments issued then by the presidency restricting a number of movements and also far-reaching directives on religious gatherings at the time. Thank you for your time, Prof. One may ask the question, how crucial is this decision but at this point to your discourse and advocacy on human rights, particularly when we know that restrictions around COVID-19 have been lifted?
Thank you for having me. I think that the decision is very crucial to the forward march of our human rights journey, because the law as it was passed did not have reference to COVID-19. And so it means that the law can be applied under different situations. Number two, the law didn't have a sunset clause. A sunset clause means that the law should have in mind an expiration or termination of that emergency when the emergency is over. That was also not provided under the Imposition of Restrictions Act. Number three, the definition of a disaster is, excuse me, a bogus one. It is completely different what is in the Constitution in the first place. And the definition itself is unclear, it's untidy. There's some words put together, which therefore gives room for interpretation of a disaster under different circumstances. So that tells you that the law was made to stay and to be used for other purposes. And so that is why it is important that the Supreme Court has struck it down, because it could have remained even after the President had issued a statement saying that the restrictions are over. And so that is why it is important to see the decision as critical to the forward march of our respect for human rights and democracy in the country.
Are you worried that the ruling is coming at this time?
Worried? Hello?
Yes. Are you worried that the decision is rather coming at this time?
Well, definitely it should have come earlier. I mean, the case was filed some time ago, and there were a number of postponements of the delivery of the judgment. However, it is not too late, because we don't know what may have happened tomorrow, where this law would have been used. So we still welcome the timing and the decision itself.
And for you, what's your expectation? In the nearest future, and for instance, when it comes to conformity, what's your expectation from the executive?
Well, we are hoping that this will be a learning curve for the executive, that they cannot take the law into their own hands. The Constitution is clear, and Article 31 and 32 on the procedures for issuing a state of emergency. We have an Emergency Powers Act, which derives its source from Articles 31 and 30 of the Constitution. We have the Public Health Act, which also deals with emergencies in the area of public health. So we have all the laws there. Why government decided to go beyond that and violate the Constitution clearly in terms of taking away the powers of the Council of State, the powers of Parliament, and so on, and violating the rights of the people when they wouldn't have any recourse to seek redress. Meanwhile, the Constitutional Article 31-32 provides means for people to be compensated in case their rights are violated under a period of emergency. So the arbitrary nature of that law tells you that government can take advantage of such emergencies to do what they want. And so it is important that such a decision is made to check the excesses that the executive can go into, and so that we go by the Constitution, which we have all agreed to.
How about legal reforms in terms of, in the form of legislation, probably from the side of Parliament? That would also help. So we have a clear guideline on how to handle some of these things when they recur, correct?
At this moment, I'm not sure we need legal reforms with regard to emergency powers. Like I said, the Constitution is clear enough and it's elaborate enough. And then we have the PHA, that's the Public Health Act, and then the Emergency Powers Act. And these provisions give room for recognition of other emergencies. For example, under the Constitution, it talks about including other situations. So it means that that particular provision is it can be extended and expanded. So I don't think we need any law at this moment to deal with emergencies. We also have elaborate provisions on human rights. We are party to the International Covenant on Civil and Political Rights, which clearly spell out the boundaries of emergencies. And it also identifies laws which can be derogated from during periods of emergency and so on. So I think we are covered in that